The Supreme Court in Katina of decisions, Manish Sisodia, Arvind Kejriwal, all cases are saying, my lord, the bail is not to be used as an instrument of punishment pre-trial. In the case of Manish Sisodia, though it's a case of ED, which is a even stringent law is there, my lords, that bail is the rule and jail is an exception, has granted. Is the order of the Honorable Supreme Court in the case of the co-accused Sunil Kumar Agrawal, framing the various questions and granting bail. Thereafter, my lords, at page 88 is my bail application in which I was granted temporary bail. And thereafter, my lords, that temporary bail has been confirmed, and that temporary bail on 7/8/2024. So my submission is, my lords, in that case, there was a prima facie case against me. My period of detention and other legal issues have been considered. The fact that whether I would withstand the trial, whether I am in a position to influence the prosecution, witnesses, etc., were taken into consideration by this court. But the Supreme Court has found a case where I am entitled for bail. So my humble submission would be, my lords, though I'll be addressing my lord's query about the prima facie case, my involvement and all, in one line, that all the allegations, my lords, taken on the face value are not sufficient to implicate me. They are inadmissible evidence. And that inadmissibility and the correctness of that can be taken care and will be taken care during the course of the trial. At this stage, it cannot be taken into consideration. Now, for the sake of argument, my lords, even if the allegations are taken as they are, my lords, whether it is sufficient, what is the punishment, my lords? The punishment, maximum punishment is 3 years, or in some matters, my lords, 7 years, not more than that. In a case of economic offense also, when the investigation is complete, the charge sheet has been filed, and the case is pending, the principles of bail is a right and jail is an exception, and Article 21 does not, my lords, get wiped away. And in case of Sanjay Chandra, my lords, the Honorable Supreme Court, my lords, have dealt it, my lords, number of times. Again, my lords, for sake of my satisfaction,
Yes.
I'll
Mr. Sinha, you have been arrested on 24/5/2024.
yes, my lords, if I take this arrest for 24/5/2024, my submission is that charge sheet has been filed. I am not required for the purpose of investigation. The only question that is now to be considered is whether I'll be readily available for facing the trial or not. The Supreme Court in Katina of decisions, Manish Sisodia, Arvind Kejriwal, all cases are saying, my lords, the bail is not to be used as an instrument of punishment pre-trial. Now, the Honorable Supreme Court has reiterated the earlier case laws and have said that even in a case where the apprehension is expressed by the investigating agency that he is a well-placed officer or well-placed person and he is in a position to influence the trial, all the conditions can be imposed, but that cannot be a ground at future possibility to deny an accused a bail who is in trial. So in this case, my lords, there are over 138 prosecution witnesses. The charge sheet runs into 1,000 pages, my lords. 6,500 pages, my lords. The charge sheet runs into 6,500 pages. The prosecution sanction under section 19 has not been granted. For that, my lords, I'll straight away take my lords to the charge sheet itself, which specifically says कि अभियोजन स्वीकृति भेजा गया अप्राप्त है. That is at page.
Who has to give the sanction? Central government.
Central government has to give the sanction. So the submission is, it's at page 57. लोक सेवक श्रीमती सौम्या चौरसिया, श्रीमती रानू सामू, समीर बिश्नोई, शिवशंकर नाग एवं प्रदीप कुमार के विरुद्ध अभियोजन की स्वीकृति हो तो प्रतिवेदन प्रेषित किया गया है. अभियोजन स्वीकृति अभी अप्राप्त है. So आज की तारीख में the trial cannot proceed, my lords, in view of the statutory prescription के 19 court cannot take cognizance. So I am languishing in jail. The present applicant has also, my lords, apart from that, she being a lady and she has got a 7-year-old child. Now, what is the consideration, my lords? My humble submission is, my lords, when the Supreme Court has on identical set of facts granted bail, my lords, there is no allegation of misuse of that liberty, my lords. I should be granted bail. That's my limited submission, my lords.
Yes.
Now, for that, my lords, I wish to without taking much time of the Honorable Court, my lord, I wish to point out, my lords, few judgments, my lords.
Yes.
My lords, sir. My lords, the first is, my lords, I have in the compilation at serial number 13 Malot, it's page 137.
Yes.
In the case of Manish Sisodia, though it's a case of ED, which is a even stringent law is there, Malots, the Honorable Supreme Court, while considering from para 51 to 57, that bail is the rule and jail is an exception, has granted bail, Malots, because he was not required. The second case is of K. Kavita, wherein, Malots, about 4 to 5 months of prolonged incarceration was there, and the bail has been granted. In my case also, Malots, I am in custody from 23/5 एंड आज जो है 23/5 से 6, 7, 8, 9, 5 महीने तो हमको हो गए. तो आई एम सिमिलरली सिचुएटेड लाइक इन केस ऑफ के कविता दैट 5 महीने हो गए हमको जेल में एंड द ट्रायल इज नॉट प्रोसीडिंग एंड इट विल नॉट प्रोसीड टिल द सैंक्शन इज देयर. In just continuation, I wish to also point out that the decision of our own High Court in Gurjinder Pal Singh case, wherein the prosecution sanction was not there, it was an economic offences case registered by ACBOW. This court has granted bail that is not required. That is at compilation serial number 19 minutes at page 333 onwards. In bail, decreasing the bail. The next case is minutes. Just to satisfy the conscience of the court, the allegation is that the co-accused in this case, the ED co-accused has given a statement कि ये मेरे पास जो डायरी है, डायरी में जो RS लिखा हुआ है वो रानू साहू है. तो statement of a co-accused made under section 50 is inadmissible, and in case of Prem Prakash versus Union of India 2024 SCC on line 2270 para 37, the Supreme Court has held the co-accused statement against appellant will not have character of substantive evidence in PMLA case. If it is not a substantive evidence in a PMLA case under which under section 50 it was recorded, it cannot be a substantive evidence in case of 161 statement recorded under the CRPs. Likewise, in case of Arvind Kejriwal, para 22, 23, 25, 26, 28, 29, 30, 31, 38, and 41. These are the paragraphs wherein the Supreme Court has considered, if desire, I can read out the relevant paragraphs, but the principle that has been made is that incarceration in the manner in which the arrest was made, after the ED arrested, thereafter is released, the CBI arrested, and therefore the manner is bad. The apprehension that he is a chief minister and he can influence, no. The conditions can be imposed, but that will not be a ground to deny bail. Article 21 still exists and it has to be given due weightage. Now, the other case, even if there is a prima facie case, the bail is not to be denied as a punishment. Is Bhagirathi Judeja's case at serial number 5, that is 1984 1 SCC 284. The relevant is para 5. Though it was a case of bail cancellation, the Supreme Court considered, and while considering that, the Supreme Court has held. I'll just read the relevant parameters. We failed to understand what the learned judge of the High Court desired to convey when he says that once a prima facie case is established, it is necessary for the court to examine the nature of the gravity of the circumstances in which the offence was committed. If there is no prima facie case, there is no question of considering other circumstances. But even where there is a prima facie case established, the approach of the court in the matter of bail is not that the accused should be detained by way of punishment, but whether the presence of the accused would be readily available for trial or that he is likely to abuse the discretion granted in his favor and tampering with the evidence. My humble submission is she is a government officer. Though she has been suspended, she will continue to be in suspension. The Supreme Court has also observed that grant of bail will not be a ground to, not in my case, but the other co-accused bail. So that may be another thing, but the possibility of notwithstanding that trial is not there. All the conditions that the Honorable Court deems it necessary, and ultimately, the query which came from the court about it's an economic offence. In Sanjay Chandra's para 46, that is, Sanjay Chandra's case is 2012 1 SCC page 40, para 43 to 46 is relevant. I'm just reading para 46. We are conscious of the fact that the accused are charged with economic offences of huge magnitude. We are also conscious of the fact that the offence alleged, if proved, may jeopardize the economy of the country At the same time, we cannot lose sight of the fact that the investigating agency has already completed the investigation and the charge sheet is already filed before the Special Court CBI New Delhi. Therefore, their presence in the custody may not be necessary for further investigation. We are of the view that the appellant was entitled to grant of bail pending trial on stringent conditions in order to allay with the apprehension expressed by CBI. So that's my humble submission, Manoj. In these circumstances, Manoj, in these broad parameters, I may be released.
This is, yes. Next is, yes.
I'll borrow this file only, Manoj, for FIR reference and my allegation only. I'll
Yes.
refer this only, Manoj.
Yes.
Page number 34, Manoj.
Yes.
I'll be failing in my duties, Manoj, sir. In the meantime, Manoj, the applicant had gone to the Supreme Court, Manoj, for bail. There was a delay that was caused. The Honorable Supreme Court has requested the High Court to consider the bail application. On
Yes.
14th, I have filed it with covering.
Yes, yes.
Okay.
Manoj, page number 34 itself, Manoj. To part of my allegation, Manoj. Method